natural justice is derived from the Roman term jus natural. The meaning of the term is natural law, justice, equality, and good faith concepts. These values did not come from any divine power, but are the consequences of the need for the judicial thought as well as the need for the fair play standards to develop. The natural justice rule has evolved in a way that does not strike an acceptable balance between conflicting factors such as fairness to the person as opposed to realistic administrative consideration such as importance of finality, productivity, and lack of formality in administrative decision making. Natural justice is a doctrine of law, but as a doctrine of administrative law, it must go sensibly. These are the standards that should be observed by any disciplinary body when taking any action that could adversely affect the rights of individuals. It is to be seen that natural justice law are not codified anywhere. They are procedural in nature and their purpose is to ensure that the parties are served with justice.
Under right to be heard, there are two elements, which is notice and hearing. Under notice, there are three subpoints, which is first, content of charges should be informed. The ground of charges must be clear and precise. This can be seen in the case of Mahadevan against Anand Rajan. Second, sufficient time must be given to make defense. The affected party must be given an ample time to prepare his defense and file objection. The related case is Pang Mohsen against Commissioner of Police. Third, there must be disclosure of evidence or information. Any relevant material should be brought to alleged person to comment, criticize, or rebut. Next is hearing. There are two types of hearing, which is first, written and oral hearing, second, reasonable hearing. If the case is simple, then written hearing is sufficient. If the case involves with serious charges, then oral hearing is needed. For reasonable hearing, they must be given a right to counsel. Any denial of legal assistance may amount to denial of natural justice. This can be referred to case of Pat against Greyhound Racing Association. Next, reasoned decision. It is not an obligation by a adjudicatory body to give reason for any decision, but by giving reasoned decision, it implies a good administration. Under rules against bias, which is also known as Nemo Judex de Causa Sua, the first element is pecuniary bias, where it is a pecuniary interest that is used to disqualify a judge. This is related with the case of Dimes against Grand Junction Canal. Second is personal bias. Any personal relationship may create favoritism. Thus, the adjudicator is prohibited to have relationship with party in dispute. This can be referred to the case of A.K. Kripa against Union of India. The third bias is policy bias. An official may be disqualified if he personally identifies himself too much with the making of policy. Case that is related is Franklin against Minister of Town and Country Planning.
I will be presenting a various jurisdiction for Britain and India. So for Britain, I'm referring to the case of Rich versus Baldwin. Rich was the chief constable of Brighton and two other officers were charged with the offence conspiracy to obstruct the cause of justice. Rich was acquitted and the other two officers were convicted. The trial judge sentenced the other two officers and made criticism of Rich. In response, Rich was dismissed by his employer, who is the Watch Committee. They gave him no notice of complaints against him, no opportunity to make representations on his behalf, and no advance warning of the meeting of which this decision was made. Rich maintained that the rules of fairness of natural justice had been breached. The House of Lords then held that the order of the Watch Committee dismissing the chief constable was null and void. Lord Reid observed that a decision given without regard to the principle of natural justice is void. In India, referring to the case of Nawapan versus State of Gujarat, the view adopted by the courts is that an order made denying natural justice is void and null. Section 56 of the Bombay Police Act 1951 empowered the police commissioner to extern any undesirable person on certain grounds. An order passed by the commissioner on the petitioner was disobeyed by him and he was prosecuted for this in court. When the case was pending, the High Court quashed the externment order on the ground that denial of natural justice on a writ petition filed by him, which then subsequently led him to the acquittance of the appellant on charge by the trial court. The government appealed against the acquittal, and the matter came before the Supreme Court, which was then held that the order of externment affected the appellant's fundamental right under Article 19 in an unreasonable manner. This is because the order was illegal and unconstitutional, rendering it void. Thus, the appellant could not be convicted of flouting the police commissioner's order, which encroached upon his fundamental right and was made without due hearing being given, as it was void ab initio. So this is because the duty to give hearing sounds in constitutional requirement, and failure to comply with such a duty is fatal in situations where hearing is obligated by statute as it affects the fundamental right of a citizen. In Jayendra Vishnu Thakur versus State of Maharashtra, the Supreme Court of India, in its criminal appellate jurisdiction, indicated that an order passed in violation of a fundamental right or in breach of natural justice is a nullity. This is in accordance with the English position.
Assalamualaikum and hi. So I'm going to present the position of natural justice in Malaysia, Singapore and Australia. First of all, both Malaysia and Singapore has agreed that failure to observe the right of natural justice will render any decision made by the court to be void. Decision made must be free of bias, conflict of interest, and person which affected to such decision must be given a prior warning and opportunity to comment. In Malaysia case, which is Surinder Singh Kanda versus Government of Federation of Malaya, the Privy Council has declared the order of dismissal as void and is contrary to the natural justice. Meanwhile, in the case of Singapore, Pang Mohsin versus Commissioner of Police, the plaintiff dismissal also held void and inoperative on the three grounds, which include a bias hearing. It was stated that plaintiff was not given adequate notice to make an answer to charge. Therefore, the dismissal was rendered as void. In certain cases, the court has asserted that it has discretion to refuse a remedy for breach of natural justice when it thinks by observing the right of natural justice, it would not make any difference to the results or their decision. In the case of Baltin Tinggal Sindian Berhad, this is the Minister of Resource Planning and others, the High Court claimed that the court power to give a remedy in case of breach of natural justice is discretionary. Moving on to the natural justice position in Australia, I King Judge in Forbes versus New South Wales Sporting Club Limited has given a statement which from that statement it can be understood that the decision which is made without applying the principle of natural justice cannot be regarded as a void ab initio, so that what purports to be an act fully inoperative. However, such an act is considered to be valid and operative until its validity is challenged and it being upheld as a void from its inception, not from time of the decision to that effect. Meanwhile, in the case of Minister for Immigration and Multicultural Affairs versus Birdwatch, the Godren and Gumo judge given the judgment and saying that in a joint judgment, it is unnecessary to describe erroneous administrative decision as void, voidable, invalid or even null. When such decision is made, it tends to ignore all the facts and issue whether the right and liabilities of individuals affected to such decision is specified in that decision. That's all from me. Thank you.
We will be moving on to the next part, which is commentaries. In India, the principle of natural justice are rules that are made to secure justice and also in order to prevent failure in providing justice. The principle of natural justice will depend upon the facts and the circumstances of the case. The general rule of principle natural of justice is to treat as a nullity an order made without observing natural justice. There are two decided cases that can be referred, which are Nawab Khan against State of Gujarat and Jayendra Vishnu Thakur against State of Maharashtra, which is a criminal case. The principle of natural justice was sufficient to protect fundamental rights of Indian citizens. The court in India also clarified that any violation of natural justice will directly or collaterally challenge in legal proceedings. While in Malaysia and Singapore, both countries agree on the same matter, which failure to observe the right of natural justice will render any decision made to be void. The principle of natural justice will provide the right for adequate notice, fair hearing, as well as unbiased hearing. The right will allow the parties to prepare for the hearing, give time to the party in presenting the case, and also question the case presented by other party.
Moving on to Britain, there are a few drawbacks to be highlighted under this jurisdiction. Firstly, a mere avoidable decision made by the authority cannot produce court relief to the person affected. Next, it is based on the discretion of the court. This shows that this right is not an absolute right, as the right to personal liberty. Plus, it can only be brought by the person who are affected, namely the person who have the local standard. And most importantly, this right was supposedly to be unlimited and available for all time, had become a total opposite when it is subjected to the lapse of specific period. Whereas in Australia, the court may completely ignore the right of individuals affected if the court does not find that it is proportionate. It may be only challenged if it is brought again in the higher court. The judgment of the court can be regarded as void ab initio, after proven that the right of natural justice is not given before the commencement of the case. Most highlightedly, it is not the court's priority to give consideration whether to grant or to refuse to give the natural right according to the person's basic right. From our point of view, the doctrine of natural justice is very crucial in determining whether full protection is given to all citizens. However, if we look from the court's perspective, it would perhaps suggest it to be inadequate. First, the complexity of the court procedures, starting from the right of the date setting of a hearing, provide sufficient and early notice to the concerned parties, giving enough time and space to the parties' argument, and until the last step to resolve the dispute between parties without fear of waiver. However, it is questionable as to whether natural justice could be possibly overlooked. In addition to that, the court's discretion to choose whether to grant or to refuse relief should be seen as improper, as defeat the whole purpose of it being natural. These are some law enactments passed by the Parliament which is in contradiction with the natural justice that allows a person to be arrested, detained or restricted without the rights to challenge their reason of their incarcerations. Our stand remains to be natural justice in its traditional context is considered to be insufficient to afford necessary protection to the citizens itself. The position of natural justice in all jurisdictions that fail to act as a shield to those affected. Thus, we urge departure from these traditional preferences in order to further expand the scope of natural justice that would in turn avoid abuse of power and strengthen the protection of individuals of their own natural rights.
The laws of natural justice are versatile and cannot be measured, nor can they be placed. It depends on the degree to which an individual's rights are affected. These laws have a role to play in ensuring justice for all parties. There can be no presumption of their contravention until injustice has been proven. Only representation may be adequate in some matters, while in others it may be appropriate to have a full hearing or cross-examination. What the court must examine is whether either of the parties are likely to be biased by failure to adhere to any of the laws. It is only when natural justice continues to be an integral part of all legislation, that basic right, that is